Thanks very much. Mr. Clark, could you, are you aware that the FBI executed a search warrant with respect to the Fulton County election records and seized a considerable number of records?
I'm aware from the news, yes.
Did you have any contact with any person within the Department of Justice or the FBI relevant to that search warrant application or that search?
No, during that time period, if I'm remembering correctly, I was at OMB.
No one reached out to you?
No one reached out to me.
How about the witnesses that were in the search warrant application? Did any of them have any contact with you related to that search warrant application or that search?
I don't know who the witnesses are, but to my knowledge, no.
Let's go back to your Georgia letter when you were in the Department of Justice. As I understand it, you had been in the Environment and Natural Resources Division, which has no authority over elections. You had been acting chief of the Civil Division as people.
At this point, the confrontation shifts from factual awareness of FBI warrants to Clark's professional background. Senator Whitehouse is actively undermining Clark's authority by highlighting his lack of experience in election law, setting the stage for a debate on the legitimacy of his actions at the DOJ.
Division as people cleared out at the end of the Trump administration, again with no role in elections.
Incorrect.
And as best I can tell, you had no prior experience in elections law. Is that correct?
Also incorrect. So both things are incorrect. I ran the two divisions, the Environment Division and the Civil Division, total of 1,400 lawyers simultaneously. And the Civil Division did have several election cases. There are two major sets of them. One were you directly involved in any of those cases? Yes. There's one in particular I will tell you about, which
well, that's
totally
okay.
goes
I'm asking the questions here, so let me continue. When you wrote that letter, who in the Civil Division did you contact with respect to its contents?
That is something that would be law enforcement privileged inside the Justice Department.
No, it's not.
It absolutely is, Senator. What lawyers I consulted and what they said and what I said to them.
The heat intensifies here as the argument over law enforcement privilege begins. While Clark attempts to use legal confidentiality as a shield to avoid naming his consultants, the senator flatly rejects this, creating a deadlock over what information Congress is legally entitled to receive.
Said to them, all of that is something.
No, what lawyers you consulted, maybe what you said, but certainly what lawyers you consulted. I'm entitled to know if you bothered to consult a single lawyer in the Civil Rights Division before you did that. But I'll turn to a different question. Who from outside the Civil Rights Division or outside of the Department of Justice gave you advice about that letter?
In terms of that letter, again, anything related to how that letter was formulated is law enforcement privileged.
That just ain't so. And let me ask that the record include the Board of Professional Responsibility opinions with respect to throwing out Mr. Clark's claims, false claims of privilege. So let's just say that somebody from outside the department put you up to writing that letter and told you what they wanted in it. What privilege would that require?
Well, there, Senator, hopefully I can help you by assuring you that there was no one from outside the department who put me up to writing a letter. I'm quite capable of writing a letter, thinking about it, and making my own legal decisions.
The focus now moves to external influence. Senator Whitehouse is probing whether the content of Clark's letters originated from outside the Department of Justice. Despite Clark's insistence on his own legal drafting capabilities, the pressure mounts regarding potential third-party contributors or hidden agendas.
Legal decisions.
No one contributed text to you. No one contributed ideas to you. No entity or person asked you to do this.
Again, these kinds of things would be part of privilege.
No, they wouldn't.
They
You're
would.
just wrong about that.
Well, you can say that, Senator, but I disagree with you, and I
I
don't
know,
what
but
you're
you've
gonna
asserted
refer-
privileges before, and you've been wrong. You assert privilege willy-nilly with no real basis for it. So, by the way,
I
it's not
disagree
even
with that
conceded that
recommendation.
those privileges matter in Congress. In fact, Chairman Grassley has repeatedly said that there are a number of privileges, and I think many of us agree with him, that simply don't pertain to congressional investigations because of the separation of powers. So what we're asking about here is whether you were put up to this by outside entities, whether those outside entities helped get you the meeting in the Oval Office with Representative Perry, who was behind that, and who was behind finding you a dark money-funded landing pad once the Department of Justice tenure was over and you were picked up by a dark money-funded advocacy group. Those are legitimate questions.
In this final segment, the senator brings the investigation to a climax by mentioning dark money and the Oval Office. He frames Clark's tenure not as independent service, but as a coordinated effort supported by outside advocacy groups, leaving the listener with a picture of deep-rooted political entanglement.
Legitimate questions. I intend to pursue them. My time has expired.